Good evening. Welcome. Kent County Board of Adjustment, February 20th, 2025. Jamie, can you please call roll?
Mr. Gallo?
Here.
Miss Denny?
Here.
Mr. Jenkins?
Here.
Mr. Carter?
Here.
Miss Hudson?
Here.
Mr. Cusick?
Here.
Thank you. That's 6 present.
I think with 6 present, we have a quorum. At this time, we'll have introduction of staff.
Thank you. Yes, my name is Jesse Lindenberg. I will be residing as the hearing officer for tonight's meeting. To my left is Jamie Fensky, another planner in the office, and to her left is Mark Kennedy, our IT specialist. And then down at the end, we have Mr. Fred Townsend. He is the legal counsel for the board.
Thank you. At this time, everyone please stand for the Pledge of Allegiance. Any additions or alterations to tonight's agenda?
Yes, sir. Application A2415 will need to be removed from the agenda. The applicant has asked that the application be postponed until the March meeting.
Thank you. And now we have the public hearing introduction.
Good evening, everyone. My name is Jesse Lindenberg, and I will preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471 to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on February 2nd, 2025 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. Now we'll have a statement by counsel. Mr. Townsend.
Thank you, sir. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The legal standard for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, the board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And this is also where the board considers whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board's not permitted to consider factors other than the four I listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on 1, the nature of the zoning district, 2, the characteristics of the area, 3, whether the requested variances would seriously affect neighboring properties, and 4th, whether applicants are confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from the presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is not authorized to resolve those disputes. Mr. Chairman.
Thank you. Now we'll begin the public hearing.
The first application tonight is A2503 for Chris and Lisa Kalmas. They are seeking a variance from the requirement that an accessory dwelling unit be placed behind the principal dwelling to enable an accessory dwelling unit application. The property is located on the east side of Moonshine Court, approximately 233 feet south of Pickering Beach Road, east of Dover. Levy Court District is the third, and the zoning district is AC. So you can see here the blue is the required setback. Since it's off of a cul-de-sac, it's kind of at a curve there based on where the house is being built. And then in the red is the proposed ADU, and they're asking to be 66 feet from the road, or the property line. There's a picture of the posting. This is looking up the driveway, so you can see just in the back the principal dwelling. This is looking to the side from the driveway of where the ADU is proposed to be. Another shot looking towards where the ADU is proposed. This is looking back up the driveway, so towards the main road. And another shot closer by the main road of the driveway. On the other side, the aerial, and further out. So if one of you would like to come up, please state your name, your address, and allow our attorney to swear you in.
So my name is Christopher Kalmas. My current mailing address is 2024 High Street here in Dover.
Mr. Kalmas?
Yes.
Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may proceed.
Thank you. The only issue I think that came up in the recommendation report was on point number 4, the hardship. The space, we certainly have enough space to put it in multiple places for our ADU. What's not shown in the images though, but is on the actual site plan, is we have 2 areas that are acceptable for septic. And the one area that we did use is right next to the primary residence. And it's at the maximum size for a 4-bedroom home at the moment. And any additional space would require a new septic area. So on the northwest corner of the home, close to where the ADU is proposed, is another septic site where we would be able to install septic for the ADU. If we were to put the ADU behind our home, we would not basically be able to do it because we would need a larger septic system and a larger leach field, and the septic area is not large enough for that size of a leach field. So other than that, I think everything else we're in agreement with, but that was our only point that we wanted to bring up.
Thank you. Any questions?
Yes, what is the proposed size of the ADU? You have any numbers on that?
It's roughly 1,200 square feet. Oh, is it 800? I'm sorry, it's 800 square feet.
So I think we have the site plan up now. Can you just, I think you use the computer to your right. Just point to the area where you're talking about for the septic.
So right there is where the septic would be. I do have a printed copy with me as well.
Yeah, you could hand it to the staff members.
Okay.
pass it around. Thank you.
How far is that septic location from the front property line?
From
You have any idea?
I'm sorry, the one in the northwest corner?
Yes, the one you just pointed out.
Yes, from the property line, it's adjacent to the property line, and it comes into the easement area by probably about 10 to 15 feet.
So that's 10 or 15 feet from the front property line, or no?
No, I think from the 35-foot easement, I think it extends beyond that.
So you'd have to add 15 feet onto the 35, or?
Correct.
So just touch base a little bit on the location. So I think I saw mention that close proximity to the existing driveway, correct?
Right.
And then it looks like you sort of split the difference between the septic and the driveway. Is that pretty much how you determine this location?
Correct. Yeah, so it'd be a short access from the front of the driveway for her to be able to pull in, but also close proximity to that septic.
Did you get a professional assessment regarding the septic and its placement?
Yes, so we actually did talk to DENREC as well, as far as the ability to have both. And the site plan showed, when we were looking at the septic, our builder originally looked at both sites. And the front system could have been a regular septic system. The one that's closest to our property had to be, or I'm sorry, closest to our primary home had to be a mound system. And so that was because that was closer and they didn't have to run as far all the way to the front of the property. That's why they built our existing septic at the back mound system.
So did DENREC rule out those other locations on your property regarding the secondary septic system?
No, it's just those two areas that were approved. You're welcome.
Any consideration into lot consolidation at all, or was that taken into account? Or
So we did look at that. The way that this property was set up before we purchased it was a subdivision, and we basically were not able to subdivide it further. And the wetlands certainly made that a lot tougher to be able to subdivide.
Can you point out on the, somewhere on that diagram, maybe we might need to see another one, where those wetlands are located?
Yes, so the wetlands are in this area here. I don't know if it's moving up on the screen. Yeah. So the wetlands are this triangle-shaped area right there.
Just confined to that area?
Correct.
You have an idea how much land that might be?
I think it's approximately half to 3/4 of an acre.
And you have 4 acres we're dealing with, correct?
4.5.
Thank you.
any other questions? Nope. I think we're good. Thank you.
Thank you.
Is there anyone else that wants to speak in favor? Is there anyone online that would like to speak?
We have no members from the public online at this time.
Thank you. Anyone that would like to speak in opposition of the application? Seeing none, we will close the public hearing for A2503.
Okay, next we have application A-25-04 for Polanco P&I Properties. They are zoned BG, general business. They are seeking a variance from the requirement that off-street parking and loading areas be located a minimum of 15 feet from the front property line to enable the submission of a site plan. The existing use is apartments. Proposed use is a professional office. It's in the Levy Court District 6 for Mr. Hertz, located on the west side of South DuPont Highway, approximately 0.37 miles south of Plymouth Road, north of Felton. You will see here the proposed site plan. The building is existing, that is there now. They are just going to do interior renovations. There is currently, you'll see in the aerials, but a U-shaped drive that they are replacing with the existing, or with the proposed parking here. The parking will be 12 feet from the front property line. It is required to be 15. You'll see the requirement in blue and the proposed in red. They are also seeking to do a cross-access with the property next door, so there will not be a direct entrance or exit to this property from the road. This is again looking at the existing building that will be remaining. Down the highway, heading south, heading back north. This is the building just about right at the property line. You will see the U-shaped driveway there. This is the neighboring property that wraps around the side and the back. The aerial, and the farther above. So Mr. Minnick, if you would like to state your name and address and allow our attorney to swear you in.
My name is Kevin Minnick from Minnick Engineering. My business address is 868 Greenwood Road, Greenwood, Delaware.
Mr. Minnick, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. We're here to ask for the variance that Jamie was talking about. We did meet with DelDOT on this project virtually, which seems like their MO. So we did meet with them. We had a meeting with them through Zoom and talked to them about, originally we talked about having a separate entrance for this parcel along with David and Doreen own the parcel to the north also. They suggest that we try and get doing a cross-access easement and have one entrance through there, which we did. So the 15 feet was never part of the discussion with DelDOT. So I was kind of surprised that they came back with comments when we submitted an application to Board of Adjustment, but they did. So basically what we're asking for is pretty straightforward. The county code requires 15 feet from the right-of-way for the setback. By the time you put all your numbers to it, the building is where it is. They're not moving the building. It's an existing building that they're going to renovate. You stay 10 feet from that to the edge of the parking to meet the fire marshal requirements. You're 18 feet for the parking stall and the 24 foot for the cartway width, and then you're down to 12 feet from the front property line. The county code reads 15, so we're asking for a 3-foot variance. It's pretty straightforward. So DelDOT's, I guess their comment was you need 45 feet from the inside travel lane, which we have 43, I think that's what's on there. 42. So yeah, what they're basically asking is they want their full 15 feet of permanent easement. Now there's a way that you can ask for a deviation from DelDOT, and they said that we could request a deviation from their code asking to go down from the 15 feet to the 12 feet. So if we were to get this variance, that's what we would ask DelDOT for. Basically reduce their permanent easement down by 3 feet.
Very good. Any questions?
Well, I have a question, but I'm not sure whether it's for you, Mr. Minnick, or it's, so DelDOT at the moment is saying it needs to be 15, but you kind of in conversation, they said.
Because when I found out that they made these comments, I contacted DelDOT again and talked to Will Mobley over there, and he said, yes, you can, and I probably should have brought that email, but it was by email form. He said you can submit for a design deviation when you submit the plan.
Okay, so we could approve it, but in the end, we all know.
In the end, I may.
Del Dot gets what Del Dot wants.
In the end, I may come back and ask for a reduction from the cartway width from 24 to 21. So, you know, we already made the application as it was, so we figured we continue forward rather than pull it and come in with something else, and then we'll just, you know, if it works, it works. If it don't, we'll probably be back. Because, I mean, I do see it as a practical difficulty. We're trying to improve the site. They purchased the site. They're cleaning it up. It's going to be a lot nicer. It's going to be for 3 office buildings, but you do need the parking. So we could say, oh, well, let's not put the parking out front. Well, that's kind of, wouldn't be very practical, I'll put it that way. So.
And of course, at this point, we can imagine what offices might be there, but we really don't know what office would be there. And it could be an office where you go in and there's an employer and a receptionist. And so, you know, one client at a time
They're looking
comes in.
towards probably professional office, if I'm, you know.
Yeah, obviously, it's,
But you would still probably need at least a couple cars for each unit, I would say.
okay.
Mr. Minnick, that concrete sidewalk, that's currently there, right? That's not
There's,
proposed.
well, the sidewalk is actually up against the building, the way it is now. I don't know if you could bring that photo back up. So whether we, you know, take that sidewalk out and readjust the sidewalk, but I did have a conversation with the fire marshal, and they're not gonna really give on the 10 feet. If it was under 1,500 square feet, which it's at 1,800 square feet, then you wouldn't need 10 feet. But because it's over 1,500, you need the 10 feet for a 1-story building for access.
Okay, so the parking can't be located any closer to the building?
Yeah.
Because of that restriction?
Yeah, I mean, the sidewalk's shown within that 10 feet, but the edge of the parking is physically 10 feet. That's what I'm showing on the plan.
Another thing, the building is legal non-compliant, I presume, with respect to that side
really
yard setback?
The parking's really at the property line now on the south side, so we're gonna make that a little better by pulling that away from the southern property line.
The building itself, though, is legal non-compliant with that side yard setback, right?
Right.
So are you limited, or is your client limited in how much they can invest in these improvements without having to bring the whole building into compliance? I don't know if Kent County has that requirement, but many jurisdictions do, that if you're exceeding 1/2 of the value of the existing structure, then you've got to bring it into compliance. So the answer is no, not in Kent County. Okay.
By that, you mean you would have to bring that portion of the building within the setback?
You might have to redevelop it entirely.
Mm-hmm.
In certain jurisdictions, if you were going to spend more than 50% of the value of the existing building on renovations, then you've got to bring it into full compliance.
Kent County does not have that? No?
No.
Okay.
I have just one more question, and it's really just to get it in the record. How old is this building? I mean, obviously, all this is grandfathered in, so how old, how long?
That building is probably, I bet you it's every bit, it's over 20 years old, I bet.
Yeah.
Yeah, I would-
In my head, I'm almost thinking like 35 or 40.
I mean, it probably goes back to the black and white aerials.
I was thinking
Yeah.
35 or 40, but,
Yeah.
okay.
Very good. Any other questions?
Without committing to it, but I have a question. If the board opted to reduce the size of the parking lot, would that be acceptable in the plans?
to reduce the, like the cartway width to 3 feet.
Yes.
Yes, that would be acceptable to us. It's just that I was gonna ask Jamie that, but you'd almost have to re-advertise it, so I don't know that,
Yep.
that legally you can do that.
If this application were denied, I think the application that might follow, that was described by Mr. Minnick, would not be the same application, and therefore we could hear it. So I don't think there's any jeopardy in terms of going forward with this.
Good. Any other questions? Good, thank you.
Is there anyone else that would like to speak in favor of this application? Is there anyone online?
Still no members from the public online at this time.
Thank you. Is there anyone that would like to speak in opposition of this application? Seeing no one, we will close the public hearing for application A-25-04, and that's our last public hearing application.
All right, let's keep rolling. We'll go into the business meeting. You want to do roll call?
Yes, sir. Mr. Gallo?
Here.
Miss Denny?
Here.
Mr. Jenkins?
Here.
Mr. Carter?
Here.
Miss Hudson?
Here.
Mr. Cusick?
Here.
Thank you. That is still 6 present.
Thank you. Now we need approval of the business meeting minutes from January 16th, 2025.
I'll make a motion to approve the business.
Second.
Got a motion and a second. All in favor?
Aye.
Aye.
Notice of decision, approvals of the notice of decision from the January 16th, 2025 meeting. Need a motion and a second.
I'll make a motion to approve the notice of decision, application A-2502.
Second.
We have a motion and a second. All in favor?
Aye.
Aye.
Old business, none. We'll go into new business.
Okay, the first application is A-2503 for the Calmas. They are seeking a variance from the requirement that an accessory dwelling unit be placed behind the principal dwelling to enable an accessory dwelling unit application. They're looking for the ADU to be 66 feet instead of 210 feet or greater.
Any comments or motion?
I have one just comment. When I first looked at this, and I thought 144 is a big number. Doesn't necessarily mean that's how I vote, but we don't usually get this amount. Obviously, we have this huge area that's dedicated to wetlands, and it's not just the wetlands, but of course the buffer adds. But and my first thought was already addressed, because when I looked at this, I thought, well, why don't they just subdivide the property and make it 2 lots? But obviously, we had an answer to that. So that's just my comment.
Yeah, I think it's a unique lot here. Sits back off the road, which is a plus. I think the septic system is key item here to think about. Yeah, and the applicant addressed the lot consolidation.
I mean, when I look at it, I thought, well, why don't take this 99 feet and at least move it back? Maybe come up with 10 or 12 feet further back. That made sense to me, just because, again, But 144 is just a big
Yeah, I mean,
number.
I think just doing it just to do it, it doesn't make much sense, especially with the septic. Just incurring cost, just to do it, with that septic being in that location, I think they picked a pretty like a mutual point between the septic and an existing driveway. Any other comments or motion?
Well, just on the conversation of the septic systems, you know, it does, in this situation, it is playing a factor in the whole scheme of things in terms of what they would like to do. I guess it's fortunate, I think on the primary residence, he said they had to have a mound system, and we're fortunate that that's not the case with this other accessory unit. I think they said a standard system was already approved, I think.
I'd add, if there were members who were inclined to vote in favor, that you would also perhaps take into consideration the presence of the wetlands area and the buffer that surrounds it as being a further limitation on where the home is placed.
Yeah, because when part of the testimony, I think I asked about the size. I think he said a half acre.
They're like 3/4 acres of wetlands.
I make a motion for A2503 to approve.
Your reason, please.
Okay, my reasonings would be, I believe that the wetlands area creates a unique situation for this property, and I believe removing the restriction does not seriously affect neighboring properties. And I believe what makes this property different from others is the inability to subdivide with the wetlands and the buffer area needed for the septic.
Second.
Got motion and a second.
Thank you. Ms. Denny?
Had to call me first.
Sorry.
I'm having difficulty. I just have finding. I mean, I'm just gonna. The size of the wetlands definitely creates an exceptional practical difficulty. My preference would have been that this be moved back a little further, just to make it over 100 feet, maybe a little bit more. But, and I don't see, I mean, there's nothing marked on the map that I'm looking at that says anywhere, like, if you're looking at that map ahead to the right, if it were to go back, that there's, anything obstructing that being there. But I don't know. I guess all I can say is I'll vote yes because the wetlands create an exceptional practical difficulty.
Thank you. Mr. Carter?
I vote yes on the motion. Based on the constrictions on the lot, I think it creates a practical difficulty.
Thank you. Mr. Gallo?
I vote in favor of the motion. I think that the applicant demonstrated the layout of the lot would require a placement somewhere close to where they chose for the home. And a failure to remove that restriction would create an exceptional practical difficulty.
Thank you. Mr. Jenkins?
I vote in support of the motion for application A25-03 for a couple of reasons. First, based on the testimony of the applicant, and two, you have to factor in the septic conditions and the wetlands. It all plays a role in what they're trying to do here.
Thank you. Ms. Hudson?
I vote yes in favor of the motion, or per my motion.
Thank you. Mr. Cusick?
I vote yes to the motion. I don't think it affects any of the neighbor properties. It sits back off the road. It's a wooded lot. I think the applicant demonstrated with the septic locations, as well as addressing the lot consolidation that causes issues there. I just think this lot is just a unique property with a few setbacks here. It just makes the hardship there for the applicant.
Thank you. That is 6 in favor.
Thank you. A 6 in favor, application A25-03 is approved.
All right, next up, we have application A-2504, and they are seeking a variance from the requirement that off-street parking and loading areas be located a minimum of 15 feet from the front property line to enable the submission of a site plan. They are seeking a front parking setback of 12 feet.
Thank you. Any comments or motion?
Well, it appears they're not asking for any more than they need. I mean, it's the minimal amount that they need, that they're requesting.
Agreed.
My only comment would be I'm fairly familiar with this area, and this improvement is going to greatly enhance what's already there. There's been some previous improvements in the area, in that particular area, and I think this one here will also enhance that area greatly.
If you're ready, I'm prepared to make a motion. Okay, so I make a motion to approve application A2504 and based on the staff recommendations, and I think it's well said under item number 4, which is failure to remove the restriction would allow parking to go 12 feet from the property line would create an unnecessary hardship for the property owners in relation to, and it goes on, and I took the paper away, so I put the paper under this one. So I really think that this does, in my mind, create the exceptional practical difficulty that we are supposed to find before we make changes and adjustments to what our code is, and keeping in mind that our code is the code and it's not a book of suggestions. It's the law, it's the rules. But in this case, this fits right in there with exceptional practical difficulty.
I'll second it.
Got a motion and second?
Thank you. Mr. Gallo?
I vote in favor of the motion. I agree that a failure to remove the restriction would create an unnecessary hardship on the property owners. The building is established there, and the layout is what it is, and by granting that application, we're allowing them to place the parking as it's supposed to be by code.
Thank you. Mr. Jenkins?
I'll vote in support of the motion for application A25-04 for a couple of reasons. First, the testimony of the applicant as was stated, and 2, it's a very reasonable request in consideration of what is attempted to be done.
Thank you. Ms. Denny?
I vote yes. In keeping what I said when I made the motion, I think that number 1, what they're trying to do, this building breathes new life into it, and I think that it's grandfathered in, and definitely if we held to that, we would just add to what is already an exceptional practical difficulty.
Thank you. Ms. Hudson?
I vote in favor of the motion based off staff recommendation and the public testimony that we heard tonight.
Thank you. Mr. Carter?
I vote in favor of the motion based on the testimony tonight and the staff recommendation.
Thank you. Mr. Cusick?
I vote in favor of the motion per staff recommendation. I think they summed it up very well in the report.
Thank you. That's 6 in favor.
With 6 in favor, application A25-04 is approved.
Make a motion to adjourn.
Second.
Good.
All in favor? Aye.
I